Also with us, Judge Glenda Hatchett, host of The Verdict and former attorney for Philando Castile's family, and criminal defense attorney Sara Azari.
Sara, I wonder, beginning with you, one key revelation of the trial was learning that the victim who was injured, not killed, Gage Grosshurst, pointed his weapon at Rittenhouse. He was armed with a handgun, I believe, before Rittenhouse fired and wounded him. How impactful was that testimony?
I think it was impactful, and Jim, you know, as Rittenhouse's attorney, what I would argue in closing is that, look, my client used the force that was commensurate with the threat that he was facing. So with respect to Rosenbaum, who had ambushed him and chased him and threatened him all night, and then finally lunged to grab his gun, he had to shoot him. With respect to Huber, who was coming at him with what is a deadly weapon under the law, you know, a skateboard coming at your neck to whack you, you know, that was also force that was necessary because he was in imminent danger of great bodily harm or death. But then with respect to this particular witness, he had a pistol in his hand, and all Rittenhouse did was shoot his arm to disarm him. So that is a fact that I think is significant. You know, the prosecution can argue the way that it's arguing with the rest of the shootings, that this was not in self-defense, that he's a killer. But for Rittenhouse, I think it shows that, you know, how he responded to each of these men was really commensurate with the threat that he was facing.
Judge, we still have Judge Glenda Hatchett, Sara Azari with us.
Sara, Sara Azari, the other guidance early on was the judge, I don't know if chastising is too strong a word, but criticizing the defense, saying that they might bore jurors if they went over again what the requirements are under self-defense under the law, for self-defense under the law. I wonder what you thought the significance of that was.
God, no. I mean, when you're talking about self-defense, and I think the next thing that I would say is just as important is proof beyond a reasonable doubt, right? Those are things that you really want to drill into the juror's head. I mean, these are lay people. Most lawyers don't make it on a jury, so I'm assuming they're lay people. The law is what they have to follow and apply to the facts that they heard throughout this trial. I would repeat it more and more because, I mean, you know, just to err on the side of caution, I think the judge was basically saying, we'll lay it out in great detail as, you know, the first time we're giving that instruction, but then we won't do it as much in detail because we're going to lose the jury. I don't think so. I think when you're dealing with such a critical issue that someone's guilt or innocence turns on, you can't repeat it enough.
Okay, so big picture, Sara, we're about to begin closing arguments here. We're down to 5 charges. We are expecting the possibility of instructions to the jury that they have the ability to consider lesser charges than the top charge of homicide here. Tell us, in your view, how this plays out in the coming hours and days.
Yeah, I think that the prosecution is going to rely heavily on what is shown on the video, and that's why that cautionary instruction is a big deal, right? Because if that video is altered in a way or where it emphasizes something more than it should, the jurors need to know that. So the prosecution is going to rely on the video. The prosecution is going to argue that Rittenhouse had no justification to shoot these 3 men, killing 2 of them. They're going to highlight the credibility issues that Rittenhouse has. You know, he said he was an EMT. He's a poser. He said he went there to protect a business. Business owner said he never enlisted his help. You know, he lied about not shooting anyone. He said he was there.
Sara, I'm going to interrupt you there.